We, the jury, find as follows as to count 2 of the charge. The defendant, William Theodore Woodward, is guilty of second-degree murder with discharge of a firearm causing death. So say we all this 31st day of January 2018 in the area of Broward County, Florida, for person number 104. We, the jury, find as follows as to count 3 of the charge. The defendant, William Theodore Woodward, is guilty of attempted second-degree murder with discharge of a firearm causing great bodily harm. So say we all this 31st day of January 2018 in the area of Broward County, Florida, for person number 104.
Mr. Woodward, you may be seated. Does counsel for either party wish to have the jury polled?
Yes.
Ladies and gentlemen, at this time, the deputy clerk will poll the jury. That simply means that she will ask each of you individually if the verdict she has read is your verdict. If it is, you need only answer yes. If it is not, of course, your answer should be no. Madam Clerk, please poll the jury.
Juror number 66, is that your verdict?
Yes.
Juror number 72, is that your verdict?
Yes.
Juror number 79, is that your verdict?
Yes.
Juror number 85, is that your verdict?
Yes, ma'am.
Juror number 87, is that your verdict?
Yes.
Juror number 91, is that your verdict?
Yes.
Juror number 94, is that your verdict?
Yes.
Juror number 99.
Ladies and gentlemen, on behalf of the parties, lawyers, and the people of the state of Florida, I wish to thank you for your time and consideration of this case. I also wish to advise you of some very special privileges enjoyed by jurors. No juror can be required to talk about the discussions that occurred in the jury room except by court order. For many centuries, our society has relied upon juries for consideration of difficult cases. We have recognized for hundreds of years that a jury's deliberations, discussions, and votes should remain their private affair as long as they wish it. Therefore, the law gives you a unique privilege not to speak about the jury's work. Although you are at liberty to speak with anyone about your deliberations, you are also at liberty to refuse to speak to anyone. A request to discuss either your verdict or your deliberations may come from those who are simply curious, from those who might seek to find fault with you, from the media, from the attorneys, or elsewhere. It will be up to you to decide whether to preserve your privacy as a juror. Once again, on behalf of the state of Florida, the citizens of this county, the parties in this case, the attorneys, and myself, I thank you for your service in this case. And for our legal system to work, it's essential that citizens such as you be willing to sacrifice their time and perform the service that you have just rendered. At this time, you all may be excused. Thank you.
All rise.
Please be seated. All right, the jury obviously has returned verdicts of guilty, as noted by Madam Clerk. How would the parties like to proceed at this point?
Mr. Woodward, I believe is entitled to a pre-sentence investigation. Request one. Should be set for a sentencing date.
I agree.
right, so that takes usually, what, about 30 to 45 days at best? Longer sometimes?
30 to 45 is what I would say.
I will defer. I would have thought longer, but
6 weeks? Okay. All right, is there anything else we need to address? I don't unfortunately have my schedule to know when we will need to address the sentencing and be available to do so. Obviously, we need to schedule it after the pre-sentence investigation. I will order one now at this time. And how much time do the parties believe that we may need for the sentencing?
probably half a day.
I think that's reasonable.
Half a day? Okay. All right. Since the jury has rendered verdicts of guilty, as noted by Madam Clerk, at this time, then Mr. Woodward will remain remanded pending the sentencing. That pre-sentence investigation has now been ordered. And as far as scheduling the sentencing, is it agreeable to the parties to have my assistant contact you all first thing in the morning as to when we can schedule that?
Yes, in fact, it would be fine with me, probably better if your assistant scheduled it through my paralegal. She knows my schedule better than I do.
Okay.
And that would be true if Mr. Shiner himself did have conversation contact with the head of my office that he could just communicate with contact.
Okay. All right. May I have the attorney's approach, please? All right, so I will have my assistant contact your assistants in the morning. We will get the sentencing date scheduled, and we'll, of course, make the verdict forms part of the record. And again, thank you all very much. Do you?
I'm sorry, I'm reminded, in addition to the motions that I anticipated, it would be appropriate for me to request a judgment of acquittal notwithstanding the verdict at this point on the record. And I do so.
State's response to the motion?
I believe that has changed. The case now is beyond
All right, I'm going to deny the motion noted by defense at this time. And again, I'll have my assistant contact your assistants in the morning to schedule the sentencing hearing, estimating a half day needed for that. And we'll get that pre-sentence investigation to the parties, hopefully within that time frame of 30 to 45 days. And again, thank you all for your time and consideration. We will be in recess.